As a barrister, here's some guidance you might need if you're pulled over by the police. First of all, remain calm. Don't get angry with the police officer, that is certainly not going to help. And don't tell the police officer that they have no right to stop you. If you're on a road and they're in uniform, they can stop any vehicle for no reason whatsoever. They can also require you to produce your details, that being your driving license and evidence of your insurance. It's an offence not to do so, although it will be a defence to that offence if you produce them within 7 days. That's commonly known as a producer. Not so common these days, but it's certainly used as a reason for the police to pull you over. Now, what do you say and what do you not say? Well, you might remember the police caution, which is you do not have to say anything, but it may harm your defence if you do not mention when questioned something that you later rely on in court. For example, if the police asks you a question such as, "How fast were you going?" you don't have to answer that question, because you do not have to answer anything. You do not have to say anything. Even if you're under caution, you don't have to say anything. What you might say instead is to ask the police officer why they've decided to pull you over. You might ask them specifically, is this a Section 163 stop under the Road Traffic Act? Because if the officer says yes, it's a Section 163 stop, but then later say that there's some other reason that they stopped you, this will form an inconsistency in their evidence. Because if they at first tell you that it's a 163 stop, but later say that they suspected you of speeding, those are not quite the same thing. But at the same time, again, if the officer asks you how fast you were travelling, you might be tempted to say you don't know. But if you say you don't know, that means you just may not be driving with due care and attention to the speed that you are doing on the road, which of course you should be. Because if the police officer decides to charge you with driving without due care and attention, they can then say that you didn't know how fast you were driving, even though it was a simple response to a question and you may not have been under caution. There'll be various arguments about that later, but at the very least it's something that you might want to avoid saying. At the very least, you should just ask the police officer why they've stopped you. If the police ask to search your vehicle, you may be tempted to consent to that search because you may feel there's nothing wrong. However, if there is anything in your vehicle, such as a knife perhaps, that you think is perfectly legal but it turns out it wasn't, then they may discover that knife and you'd be in possession of an offensive weapon. So you might ask the police officer what their reason and what their lawful basis is for the search, because they need to have a lawful basis to search your vehicle in the first place. The most common reason is if the police have reasonable grounds to suspect that you're carrying an illegal item. This might be drugs or weapons or anything else that they consider to be illegal. But again, they must provide you with a specific reason for the search, unless they have a warrant, of course, which they should show you if they do have a warrant. If they do provide any of these reasons, I would suggest that you get our app Proofify, which will allow you to document the conversation with the police. This will produce a contemporaneous record of your conversation. You might even record your conversation with the police, because there's no reason that you can't do that for your own personal records. If it turns out that something the officer says was unfair or unlawful, you can use this in your defense later if you're later charged with something because the process might have been unfair. If the police carry out an unlawful search, it may mean that anything they find in that search would be inadmissible in court later. What you should also ensure that you don't do is give any false or misleading information, because remember, part of the police caution, anything you do say may be given in evidence. So if you are charged with anything down the line and you've said something that is wrong or misleading or an outright deception, that can and probably will be used against you in court later. Not only that, it would be an inconsistency with what you might say later, because what you say later might well be the truth and might well be perfectly innocent. But if it doesn't coincide with what you said when you were stopped by the police, then you're going to have a difficult job explaining why there's a difference. And remember, always, you have the right to legal advice if you're being questioned about your suspected activity in respect of an offence. So if you are to be questioned, you can ask for access to legal advice. It should ordinarily be at a police station. You should have access to the PACE codes and all sorts of other things. So you should ask the police officer, are you being detained? You should ask the police officer why they've stopped you. If they want to look in your vehicle, what lawful basis and what are they looking for? Because this sort of works both ways. If the police are inconsistent with why they've stopped you or what they're looking for or why they want to search your vehicle in the first place, again, all of these things might be used in your defense later, or they might be used to exclude some of the evidence. And finally, although this is probably not going to be a very popular option, if you really were speeding and the police officer shows you evidence that you were speeding, it might, in some situations, be better to just admit it, because you might then just receive a fixed penalty, whereas if you argue about it and you go to court and you lose, you will almost certainly get a higher fine, more points, and the court might even consider banning you, depending on how fast you were going. But to come full circle, the best guidance in all of these situations is to remain polite. If you argue with the police, that is just going to give them more reason to suspect there's something wrong. And finally, it's also worth bearing in mind that Section 165 of the Road Traffic Act provides the power to constables to obtain the name and address of drivers and others, any person driving a motor vehicle on a road, or any person whom a constable has reasonable cause to believe to have been the driver of a motor vehicle, or any person who a constable has reasonable cause to believe has committed an offence in relation to a motor vehicle, must, on being so required by a constable, give his name and address, and the name and address of the owner of the vehicle, and to produce the documents, as I've already explained. So please remember this as very broad guidance. Make sure you always seek formal legal advice if you think you have or you may have been involved in something. And in the meantime, please remember to subscribe, and thanks for watching.